Today's case is a crash course in debt collection law. Ashley Brown is fighting a wage garnishment, claiming she was never notified. But in Michigan, notice rules can be a maze. Will the judge side with procedure or sympathy? Let's find out.
Survey for Plaintiff P87205.
Okay, you're Ashley Brown?
Yes, I am.
Okay, today was the date that was scheduled for a hearing. This is for an objection to periodic garnishment. We received an objection from you, Ms. Brown. It states that you are objecting to garnishment because you was improperly notified of any, does that say hearing?
Yes. So I did some research, and it appears that they reached out to a few of my other jobs like Kirchhoff, Champion, and I didn't get any notice of any of those. I feel like the only reason I got this one is because they sent it certified mail, and I handle all the mail for my new job here at the Funeral Directors Association. But they garnished my taxes. I was not notified of any of that. When I've only found out that they garnished the taxes when I called the courthouse when I received this notice, because I was like, because they did. I saw the taxes were taken, but I didn't really look into it. But then I called the court once I received the.
Here's the kicker. Creditors don't have to warn you before a garnishment hits your paycheck or tax return if they've already won a judgment. That's why default judgments are so dangerous. Miss one court date, and the creditor can quietly scoop your money.
Garnishment, and they were like, oh, well, they garnished your taxes for this particular matter, but I was never given any notice of that.
Did you want to respond to her objections, counsel?
Yes, Judge, I will. Plaintiff had the writ of garnishment properly issued. It looks like that was back in July, so July 23rd, 2025. The writ was issued by this honorable court and then served on Garnishee Michigan Funeral Directors Associations, Inc. There's no court rule or statute or case law upon which plaintiff is aware that plaintiff is required to give defendant prior notice of filing its writ for garnishment, but the writ was otherwise properly issued by this court. And plaintiff would further note for the record that it sees that defendant was the person who signed the green card on the delivery of the writ of garnishment, and plaintiff still has not received the garnishment disclosure pursuant to that, despite now having noticed that defendant is the person who signed the green card, as well as, her admitting in court that she got it. So a plaintiff would ask that you deny the objection to garnishment as it's invalid. There's not a requirement that plaintiff's aware of that plaintiff has to forewarn a defendant about a writ for garnishment that was properly issued.
But you are still required by Michigan rules to notify me to. I'm sorry.
Ma'am, that's not how this works. You see how I asked her if she wanted to respond?
I understand. I'm sorry.
Okay, that's why I'm here. I'm the referee here. I get to mediate this, so you don't talk back and forth, you talk to me. So the court rule for your objection to garnishment is very clear, and there's no court rule that allows or tells you that you can even file a garnishment. That you see where you request the objection, and it gave you a section A, B, C, D, E, and F.
Listen closely. The judge is basically saying you checked the wrong box. Michigan law gives only a handful of valid objections to garnishment, and I didn't get notice of a hearing isn't one of them. This is procedural chess, and Ashley is playing catch-up.
Okay, and that's because those are actually the only ways in which the court rule allows you to object to a garnishment. You checked F, which allows you to say that the garnishment or the writ of garnishment was issued improperly or otherwise invalid, and then you wrote in that it was because it was improperly notified of any, you wasn't properly notified of any hearing. There's no hearing that comes with, you're opening your mouth to talk over me while I'm talking. There's no hearing that comes with a writ of garnishment. So I don't know what hearing you were looking for. There would have been no hearing. The other thing is, you said that it was not issued, or that writ issued after the initial hearing. Again, I don't know what you mean by initial hearing.
It's my turn to speak. I'm sorry.
That's correct. Yes.
So I was when I wrote this, it's because I literally was not notified of any other hearing even leading up. That's what I meant by hearing. So like I understand that they issued the writ of garnishment, but I was never notified about a hearing for the judgment or any of these other garnishments. Like I mean,
Oh,
how am I supposed to respond to a garnishment if I don't have this, if I wasn't served?
ma'am, you were served with the lawsuit in this matter, correct?
Uh-huh.
And then you appeared before me back in December 1st, 2022. There was a
Uh-huh.
joint pretrial statement that was completed. After that, you received your next court date. You were supposed to appear in this court on March 28th of 2023. That's over 2 years ago. You
Uh-huh.
failed to appear. Default judgment entered against you
I did not
because you
get
failed
notice
to
is what I'm
appear.
saying.
You failed to appear. You knew you were being sued. You were properly on notice that you were being sued, and the
Ouch. That's the default judgment bomb dropping. Ashley insists she never got the notice. The judge insists it was sent. Viewers, who do you believe? Mail mix-up or missed responsibility? Comment your verdict below.
court sent the notice to appear for your next court date. That came from the court, and it did not get returned back to this court non-deliverable. If your address changed from the time that this court case began, it would be your responsibility to then go and notify the court, but it doesn't even appear that your address changed. So notice was sent for you to appear in court on March 28th, 2023. You did not appear. Outside of that, wait, I'm not done yet. Outside of that, ma'am, once you fail to appear, a default judgment entered against you, and the court then sent a notice of a default judgment to that same address.
Did not receive.
So the court itself sent multiple notices to the address on file notifying you A, to appear in court 2 years ago, B, that you failed to appear and a default was entered. Once that happened, that allowed you the opportunity, if you had responded to even the notice of default, you could have came back to the court and request to have the default set aside. But you never did that, and that's quite common. We get a lot of people that ignore that paperwork, and then we hear from them once it's time for their garnishments to take place.
Is it my turn to speak?
Yeah, we haven't heard anything we haven't received or heard anything from you on this file since October 12th, 2022.
I did not receive a notice for judgment. I did not receive any notice for judgment. I don't know if they was lost in translation because I was fighting the case. I definitely wouldn't have not appeared to that hearing.
Ma'am, you were advised by this court that you were doing a joint pretrial statement and that you would have some dates that would be kicked out from the clerk's office. You knew you were being sued.
I was advised of it, but that doesn't mean I was served.
What did you think happened after the next 3 years after you came to court? What did you think happened?
To be fair, like once I did receive the notice once I received the information about the garnishment, I honestly thought that they closed the case because they garnished my taxes. But I still was not notified of any of those things. I don't understand, like I said, how I'm supposed to respond, because I would have responded to the garnishment way before now had I known about it.
Your tax garnishment is what you're talking about?
Yes, they garnished my taxes, but I did not know that.
Okay, so and that's not even what you're here for today. You're here for a different garnishment, correct?
I mean, it's all of them because, like I said, that's not the first one that they did. They did multiple garnishments or at least attempts, but there was never any notification sent to me. How am I ever going to, how am I supposed to respond to a garnishment if I don't have any notice of it? I only responded to this one because I literally received a notice.
I don't know what you mean. How are you supposed to respond to a garnishment?
But just like with this objection, like I'm objecting to it, I'm responding to it. I did not receive notice of those prior things, and I've done research on this company. This is not the first time they've done stuff like this.
Right, but I recognize you're objecting to the garnishment, but you're not providing the court with a objection that the court can consider. The court rule tells you what objections you can use. There are no such thing. There's no such thing as a hearing. There's no such thing as a hearing for a writ of garnishment. You don't get a hearing for that. I was referring
to the hearing, like I stated, that was the judgment hearing. I did not receive notice of that hearing. That's the
So the
hearing I was
court,
referring
that,
to.
okay, that
Because if
same
I
court
had
rule that
received
you're
notice
talking,
of the judgment
ma'am,
hearing, I would have
ma'am, you cannot
appeared.
continue to talk over me. What I'm telling you is that that same court rule tells you that you cannot use an objection to garnishment to attack the underlying judgment, which is what you're trying to do.
And I understand that, but what other premise can I go on if I don't have any notices? If I had gotten those notices, I could have objected earlier. That's my
Yeah,
whole
what I'm
thing.
telling you, you cannot object to a garnishment so that you can attack the underlying judgment. You're saying the reason why you're objecting is because you did not get notice of the hearing in which you got a judgment for.
But
The
it says
court
that they
rule
have to
says you
serve you
can't
with
do
these
that.
garnishments. It
No,
says
the
that
court rule says you can't do that. It says that you can't do that.
so there are no rules saying that they have to serve you with the garnishment. Is that what you're saying?
It says the garnishment has to be properly issued, and it was.
But I wasn't served it, is what I'm saying.
This is a classic trap, trying to fight the garnishment when the real fight was the judgment, a fight Ashley already lost by default. Court rules slam that door shut. Once the judgment stands, the garnishment is just paperwork.
So how was it properly issued?
They don't have to serve you with the garnishment. They have to serve your employer.
Okay, so I don't understand then how somebody is supposed to respond if they don't have the information.
No, you were supposed to respond to the lawsuit, not the garnishment.
Ma'am, and I have already stated I did not even receive a notice for the second hearing.
But you can't use you can't object to the garnishment now.
We wouldn't be here though if I had received that notice.
The court rule is very clear. You cannot object to the garnishment to now attack the underlying judgment. Do you understand that part?
I understand that, but I'm saying if I
So why
didn't
do you
get
keep
notice about the
repeating that
initial
then?
hearing,
Why
then
do you keep repeating the same thing?
Because I'm trying to get you to understand that it doesn't make sense to say that I can't attack the garnishment if I was never properly notified about the initial hearing. There wouldn't be a garnishment if I had been notified.
I'm gonna terminate this hearing if you don't let me explain this the last time. I don't have the issue of the misunderstanding. I know the court rule very well. The court rule very clearly states you cannot file a motion to object to a garnishment because you want to now argue that you missed a court date or you didn't get notice that had to do with the judgment. That's what the court rule says. So you are trying to say that you didn't get notice of the court date that you were supposed to appear for back in March of 2023. The court rule says you can't use an objection to garnishment to do that. I didn't make the court rule, ma'am. That's just what the court rule says. Do you understand that?
Yes.
So Judge, can Plaintiff respond?
You have not provided the court with a reason under the law that I can grant your request to object to the garnishment. Yes, ma'am, you can respond.
Okay, just to correct the record, Your Honor, it was actually a summary disposition judgment that was entered in 2023, and it was also entered pursuant to the notice of 7-day rule for entry of the order. So defendant had notice to appear for that hearing through plaintiff's notice of a hearing. They had an opportunity to object to the entry of the summary disposition judgment. They didn't file a response to plaintiff's motion for summary disposition judgment. And as Your Honor had already stated, it's not a proper objection to writ for garnishment when you're attacking the validity of the underlying judgment under the court rules. So it's plaintiff would ask that you deny the objection is invalid and appreciate that you've done that.
I'm trying to explain so that the Ms. Brown can understand her concern, because I'm not saying that there's no other avenue for you to go and try to figure out what happened with your notice, or according to what they filed, you were served with a notice for your date to appear in court. And outside of that, you knew you were being sued. And so when you appeared in my court in 2022, there shouldn't be a next appearance 3 days later, or 3 years later, that is. You should have appeared at some point wondering what was going on with your case, because you knew you were being sued. And they had served you with discovery. They had served you with a summary judgment motion, which the court told you when you saw us would have a deadline date. And so we advised you of that when you were last here in 2022. When you didn't respond until this objection, and you can't now attack the judgment because the court rule says you can't do it this way. And so I have to deny your motion. Okay? Okay, so if you want to, I don't know what the balance is on the.
Despite all the legalese, here's the practical path. Negotiate. Installment payments can slow or stop garnishments if both sides agree. It's not victory, but it's damage control. And sometimes that's the smartest move in debt court.
That, and I know you said that you had some other garnishments that took place. You can try to meet with Ms. Serby and see if you all can work something out and maybe enter an installment payment agreement or another kind of settlement agreement that will prevent them from trying to garnish your wages. So if that's what you want to do, I could put you in the meeting room now for that purpose, to see if you can come up to another arrangement so that they won't be garnishing your wages.
Okay, let's do that.
Okay.